Imagine this: FBI agents storm a courthouse, slap cuffs on a sitting state judge, and march her out as protesters erupt outside. This isn't a movie. It happened just last week. Milwaukee County Judge Hannah Dugan now faces federal charges, accused of helping an undocumented or illegal alien escape arrest inside her courtroom. But here's the bigger question. Can federal agents really arrest a state judge? Is that even constitutional? Today, we'll break down the legal battle that could reshape how federal and state powers collide, and why the answer isn't as simple as you might think. And spoiler, it's not the first time the feds have gone after state officials. And history shows some jaw-dropping precedents you've probably never heard of. It turns out no one's above the law. If a state official commits a federal crime, the Constitution does not shield them from arrest. In fact, this kind of showdown between federal authority and state defiance has happened more often than you might think. To understand why a judge in Wisconsin can be taken into federal custody, we have to explore how federal and state powers collide and who wins when they do. At first glance, America's federal system is like a two-layer cake. The states have their laws and officials, and the federal government has its own laws and officials. This is often called dual federalism. But when push comes to shove, the U.S. Constitution makes one thing crystal clear. Federal law is the supreme law of the land, and judges in every state shall be bound thereby. That's the Supremacy Clause, Article 6. And it means state judges and officials cannot defy valid federal laws. Every state official takes an oath to uphold the U.S. Constitution. Now, is there any legal immunity that state officials enjoy? Generally, no. Not for criminal acts. While judges have immunity from lawsuits over their rulings, they have no special immunity from criminal prosecution. In our system, no public servant is above the law. Not a governor, not a police chief, not a judge. From a constitutional standpoint, there's no barrier that magically prevents federal authorities from arresting a state official on legitimate charges. The Supremacy Clause and subsequent court rulings back this up. As far back as 1859, the U.S. Supreme Court held that state courts cannot interfere with federal actions. In Abelman versus Booth, the court ruled that no state court decision can contradict or block a federal court decision. Fast forward to 1879, the Supreme Court held that the federal government had the power to punish the disobedience of a state judge. In other words, being a state official does not put you above U.S. law. If you break a federal law, you can be held accountable, like anyone else. So constitutionally speaking, federal agents can arrest state officials when there are real, substantive federal charges. There's no clause that says judges or state office holders shall be immune from federal law. If you think the Wisconsin judge's arrest is unprecedented, history begs to differ. Let's look at some dramatic historical showdowns when the federal government went after state or local officials who defied lawful authority or obstructed justice. These stories prove that while rare, federal prosecution of state officials has clear precedent, and it's often wrapped in high drama. In 1879, there's a judge jailed for excluding black jurors. During the Reconstruction era, Judge J.D. Coles of Virginia thought he could ignore federal civil rights law. He systematically excluded black citizens from juries. Federal marshals arrested the state judge under U.S. law, banning race discrimination in jury selection. In Ex parte Virginia, the court upheld this indictment, affirming that a state official who violates federal rights can indeed be prosecuted by the feds. This case cemented the principle that state judges are not above federal law. If they abuse power, federal law enforcement can step in. 1957, it's not just about judges now. When Arkansas Governor Orville Faubus used the state National Guard to block court-ordered school desegregation in Little Rock, it set up a showdown with President Dwight D. Eisenhower. Faubus was a state official openly defying a federal court order to integrate Central High School. Ike didn't hesitate. He federalized the Arkansas National Guard and shockingly sent in 1,200 U.S. Army paratroopers from the 101st Airborne Division to enforce the law. Troops with bayonets escorted African American students into the school, effectively overruling the governor's obstruction. While Faubus himself wasn't arrested, the message was clear. the president would use federal force to uphold federal law. This dramatic confrontation with soldiers in the streets of an American city showed that state authorities cannot defy federal court orders without consequence. 1962, a few years later in Mississippi, Governor Ross Barnett tried to block James Meredith from integrating into the University of Mississippi, Ole Miss, in defiance of federal mandates. Federal courts intervened swiftly. Barnett was found guilty of civil contempt for violating federal court orders and was ordered to stop interfering or face arrest and a $10,000 per day fine. Federal marshals and troops enforced orders after deadly riots, and Meredith was admitted. The showdown demonstrated that even a governor can be personally sanctioned and threatened with federal arrest for flouting the law. Let's get a little more recent, 2018. This is a case very similar to Judge Dugan's. In 2018, a Massachusetts state judge, Shelley Richmond Joseph, faced federal prosecution. Judge Joseph was accused of helping an undocumented or illegal alien defendant slip out a back door of her courtroom to avoid a waiting ICE agent. Federal prosecutors under the Trump administration indicted her on obstruction of justice charges, conspiracy to obstruct, and obstruction of justice itself. This was essentially the same charge now facing Judge Dugan. The legal process ultimately halted this prosecution, reflecting a judgment, wholly discretionary by the Trump administration, that it wasn't in the interest of justice at that time. Each of these examples, from the Reconstruction era judge jailed for discrimination to the Civil Rights era governors forced into compliance to the modern judge indicted for impeding immigration enforcement, reinforces the same point. State officials are not immune when they obstruct justice or defy lawful federal authority. Now, just because the federal government can arrest a state official doesn't mean every such arrest is permissible. There's a fine line between enforcing the law and abusing power. Critics of these federal actions often worry about federal overreach or political misuse of authority. We have to ask, could the power to arrest state officials be abused? Where might it go too far? It's a valid concern. Imagine a scenario where a president, for political reason, starts having federal agents arrest state officials who simply disagree with the federal policy. That would indeed be a nightmare, a breakdown of our constitutional balance, and a potential slide toward authoritarianism. The rule of law is a two-way street. It protects the public from lawless officials, but it also protects officials from lawless persecution. The principle is that federal intervention is justified only when a state official has genuinely violated federal law, not as a tool to bully or remove political opponents. Let's look at the current Wisconsin judge case with these principles in mind. The arrest of Judge Dugan sparked an outcry from some who felt it was an attack on judicial independence. U.S. Senator Tammy Baldwin called the move a gravely serious and drastic step that threatens to breach the separation of powers. Such a reaction shows a real fear that federal arrest of state officials could be motivated by politics rather than justice. Even legal experts supportive of enforcement have urged caution because such actions could strain federal-state relations. Historically, we've seen both sides of the coin. The interventions of the 1950s and 60s, though drastic, are largely seen as necessary to uphold constitutional rights. In each case, context matters. Is the state official clearly violating the law and rights of others? If yes, federal action, while controversial, might be justified. Or is the federal government overstepping into a state matter for political gain? If so, that's a problem. It's important to note that safeguards exist. Federal prosecutors must convince a grand jury and then a trial jury or judge of a state official's guilt beyond a reasonable doubt. State officials, like Judge Dugan, have the right to defense and due process and a host of constitutional freedoms. In Dugan's case, she will have her day in court. Her attorney has stated she will defend herself vigorously. The mere arrest isn't a conviction. The judicial process itself is a check. If the charges are weak or politically motivated, the court should reject them. So yes, the principle could be abused if we're not vigilant. That's why such arrests of state officials are exceedingly rare. They tend to occur only in egregious circumstances, and even then, they draw intense scrutiny. It's natural that some people reacted with shock and shouted about constitutional crises. The FBI and Justice Department know that hauling off a state judge is a big deal, and they will generally only do so if they believe the law left them no choice. In Judge Dugan's situation, the Department of Justice, under President Trump, explicitly adopted a hard line against officials who actively interfere with immigration enforcement. It was part of a policy stance. Controversial in itself, but not done in secret. It was a public clash of philosophies. Sanctuary philosophy versus enforcement philosophy. People can disagree on whether that policy is wise, but legally, the charges against Dugan are based on real statutes, obstruction of a federal proceeding, not fabricated offenses. If a state official, even a judge, truly commits a federal crime, holding them accountable is not a constitutional crisis. It's the system working as designed. No one is above the law. And that principle is at the core of our republic. We should indeed downplay the more alarmist reactions in this sense. The arrest of a state judge for genuine obstruction of justice is not the end of American democracy. It's a serious, rare, and delicate action, but it's grounded in constitutional authority. The framers and later generations built a system where federal and state governments check each other. Usually that happens through courts and legal arguments, sometimes through political negotiation, and occasionally, in extraordinary moments, through handcuffs and courtroom showdowns. It can get dramatic, as history has shown, but it's all part of an ongoing story. The rule of law applies to everyone, whether wearing a robe, a badge, or a business suit. So don't panic at the sight of a judge being arrested by federal agents. It's not a coup or the collapse of separation of powers. It's certainly unusual, it's certainly serious, but it falls within our constitutional framework and history. History shows us that while federal arrest of state officials can be explosive, they've sometimes been necessary to uphold justice, and our nation has survived and even been strengthened by enforcing the principle that the law applies to everyone. In America, we the people have given no one, not even judges, a free pass to break the law. And that may be uncomfortable at times, but it's also one of the greatest strengths of our constitutional system. No one is above the law. Period. Thank you for joining me today. My goal as a constitutional litigator is to give you the tools to scramble constitutional controversies, and I aim to do so without the noise and drama so commonly found today. I hope you'll hit like and subscribe and join me next episode when we jump into yet another compelling constitutional controversy.